will be available at that point of a time? I really don't know. Let's see.
There are progress, I mean, everywhere, but the availability will be somewhere in March 2021 onwards. I mean,
Yes.
it's not something which is going to happen soon.
Yes.
So, but there is good progress, what I understand from news channels and all.
Yeah, Amrita ma'am, are we live?
Yes, sir.
Yeah, start please.
Tejashree, over to you.
A very pleasant evening to all intellectuals, honorable guests, and my respected teachers. On behalf of Kelly Society's Kelly College of Law, Navi Mumbai, I, Tejashree Sagwekar, welcome you all. I will be hosting today's session along with Dr. Amrita Singh ma'am, who will be moderating this event. Our guest speaker of this session, Ms. Romisa Bhat ma'am, has joined us. We welcome you, ma'am. Today, ma'am will be enlightening us on the topic key contractual positions for drafting and negotiating a contract. I now request our respected principal, Sir Professor Dinkar Geete, sir, to address our guest, speaker, and the audience. Over to you, sir.
Yeah, thank you. Thank you, Tejasri. A very good evening to all. A very warm welcome to our guest speaker, Ms. Romisa Bhat. Thank you, ma'am, for accepting our invitation and joining us to share your views for today's session. I'm confident that our dear participants would learn a lot from you today, as this is a very interesting and contemporary topic. And let me tell about her. She is my batchmate of National Law School 2009 to 11. She was in business law stream. She was a very good student, hardworking student, and very intelligent, rather to say, and she was a good orator as well. So I'm very much happy that she has accepted the invitation from Kelly Society's Kelly College of Law, Navi Mumbai. Thank you, ma'am. Thank you once again for joining us for this session. I'm also obliged to KLE management, especially Dr. Prabhakar Koreji, who is the chairman of KLE Society, Mr. Mahante, governing body chairman, KLE College of Law, and MLC and Chief Whip Karnataka Government, Dr. Mallikarjunaya, Principal KLE College of Law, Bangalore, and Director KLE Law Academy, Belgavi. He is also our mentor for this institution, and they have continuous support and inspiration and guidance throughout the webinar series, the management as well as Mallikarjunaya sir. So, having said that, without wasting much of a time, I think now I would like to hand over this session to Dr. Amrita. Over to you, ma'am.
Thank you. Thank you so much, sir. Thank you so much, sir, for those words. And a very warm welcome again, ma'am. On behalf of KLE Society's KLE College of Law, Navi Mumbai, I welcome you. And before giving this session to you, I would just like to introduce your good self to our dear participants. Ma'am did her BA LLB honors from Jamia Millia Islamia and then continued her studies to complete her LLM from National Law School of India University, Bangalore. Post her education, ma'am started her corporate career with L&T, a leading infrastructure development company. After more than 3 years with L&T, she joined Ansaldo STS, a Hitachi Group company, and as legal counsel India. Further, in the year 2016, she joined Hinduja Global Solutions and is now working there as an Assistant General Manager, Corporate Legal. With more than 9 years of experience, ma'am has become a subject matter expert in drafting and negotiating agreements, litigations, and labor issues. Ma'am is also involved in handling compliances and likes to conduct legal workshops. Ma'am is an effective communicator with strong relationship management skills. Thank you so much, ma'am, for accepting our invitation and joining us. And with so much experience and learnings, I think we all are going to witness a wonderful session today. Over to you, ma'am.
Thank you so much, Dinkar sir, for giving me this opportunity for interacting with your students and your faculty. Thank you so much, Amrita, for coordinating all along and making this happen. I'm really grateful that I'm getting this opportunity to share my experience and to talk to your students. I would appreciate if you have any, if the students or the faculty have any questions. So we will spare 15 minutes at last, probably, and I will try to answer those questions to the best of my abilities. So I have chosen the subject of corporate contracts actually from the drafting and negotiating perspective because of two main reasons. One is that my personal reason. Reason being that I have all along from last 9 years, 9+ years, almost 10 years going to happen, dealing with contracts, whether it is from drafting or negotiation or review perspective, or whether it is from litigation, or whether from advisory. The second reason was, as well, I was talking to Professor Dinkar also, that the students who are going to pass out will be going into a career of either the corporate, or they will be having a career in law firms, or they will going to go into the litigation. So in all these streams, you will have a interaction when it comes to contracts. Your 50%, almost 40 to 50% of your work will be relating to contracts, directly or indirectly. So that was one of the main reasons for choosing this subject. So Amrita, can I share my screen? Is it possible?
Yes, ma'am. There's a green button at the bottom of the taskbar.
Yes, yes. Just let me know if you can see my screen.
Yes, ma'am, it's visible. Ma'am, on the top of the screen at the right hand side, there are extreme right, there are 3 dots where it is written more.
Yeah.
Ma'am, you have to click on that and select disable participants annotation.
Disable annotation for others, right?
Yes, ma'am. Yes, ma'am.
Okay. I hope it is visible now.
Yes, ma'am. Yes, ma'am.
So the topic for today is key contractual position for drafting and negotiating a contract. We all know what contract is because we are dealing with contracts every day, whether professionally or in our daily life. Contract is an understanding between two or more parties. These parties can be two individuals. These parties can be two entities, or can also be two legal persons. So what does a contract do? It creates the obligation to do or not to do a particular thing. I can give you a simple example. When you're opening a Facebook account, also when during login, you will be asked to click on certain TNCs, that is terms and conditions. So that TNC itself is a contract. So when opening a social media account, you are entering into a contract. So what does it mean? That it means you offer something, and then the other party accepts it. When you go on social media, you want to have an account. So the other party gives you terms and conditions for operating that account. So that is offer, that's a proposal and acceptance. So there may be oral contracts. To everyone's surprise, there can be written contracts. But for an enforceable contract, it's always better to have a written contract. And when it comes to business arrangements, commercial arrangements, it's always better to have a contract in writing, and it should be signed. And when it comes to India, it should obviously be franked. That is, you should pay the revenue on it. So why should we have a written contract? I have explained it in this deck also, that it preserves the understanding between parties. What are my expectations from the entire contract or a project? It actually writes down that and tells us that, I mean, this is my expectation and this is what the other party is going to offer me. So it preserves the understanding. Second, that it describes the responsibilities and binds parties to those responsibilities. For example, I can give you an example. If I'm planning to buy a laptop and I have placed an order, so my understanding is that I'm going to place an order. Second, I'm going to pay for that. The other party's responsibility for that laptop will be that they are going to deliver the laptop as per my specifications. For example, if I want a Dell laptop, they have to deliver a Dell laptop. I will give them the model that I need a model of latitude 3470. So their responsibility is to deliver that 3470 to me. Then once I get the delivery of that laptop, so my responsibility is to make the payment for what was agreed in the agreement. So the financial understanding is again the same, that if I am performing services or I'm delivering a good, then for that I will be receiving some payment. So what is that payment, in what methodology that payment will be made is also mentioned in the agreement. I hope I'm audible.
Yeah, ma'am, you're audible.
Okay. The next is that, I mean, if there is any kind of dispute, if I have placed an order for 10 laptops and I have received only 8 laptops, so 2 laptops are missing, and if I want to raise a claim, that for that claim, what is the mechanism available will be mentioned in the agreement. So that is that it helps in avoiding the conflicts, because the dispute resolution mechanism is already mentioned in the agreement. So all in all, a written agreement is something which is actually beneficial for the parties, especially in a corporate setup or especially in commercial transactions. When you see any agreement, more or less, you will find these clauses which are currently available on the deck. More or less, everything will be present. You will have a name clause where the parties' names will be defined. You will have a recital clause, which actually gives the introduction to the parties. What are their expectations? Definition and interpretation clause, scope of work, fee and payment terms, representation and warranties, confidentiality, data protection and privacy, intellectual property and ownership, indemnity, limitation of liability, governing law, term and termination, force majeure, and boilerplate clauses. Boilerplate clauses are something which are available in each and every agreement, irrespective of the nature, and then annexures. I'm not going to take all of these provisions during this presentation. I will be taking up only few of them, which are very, very important, especially from domestic negotiation or review perspective, or when it comes to the cross-border transactions. First one is scope of work or services. What is scope of work? When we talk about scope of work, it is the statement of work. Statement means what are the expectations of parties from each other. So generally in main agreement, there will be hardly a paragraph which will be written. It is necessarily a second or third clause in any agreement. But there will be a huge annexure which will be of 3 to 4 pages, which will detail out the entire scope of work. A well-written scope of work defines that who are the parties, what are they going to do, when will be the work performed, where, which location the work will be performed, and how will be the work performed. All these descriptions will be given in the scope of work in detailed manner. We can always say that when it comes to scope of work, it's like a heart to an agreement. Without scope of work, the agreement can't work. It is necessary for an agreement to have the detailed scope of work and a statement of work. So there are few elements to this scope of work. One is the statement, which actually lays down the what is expected from both the parties. Where, I mean, it gives the description of work actually, or a description of service. The second part is deliverables. When I was taking the example of laptops, so deliverables means that I have to deliver 10 laptops, or I have to design a website, or I have to probably give a BPO related service. So that is my deliverable. What is the deliverable from other party? Once they receive the service, then they have to make the payment, and they have to give me some other nature of consideration. You must be aware about NICA. It's not necessary that when it comes to consideration, it should be always be in cash. It can be in some other means also. It can be a barter. For example, NICA is a beauty website or a beauty platform wherein many influencers are asked to promote NICA products. In return, they don't get cash or they don't get monetary benefits. Sometimes what they get is the visibility on their platform. So they will get their video to be put on the NICA website. So that is also a consideration. So that is taken care by the deliverables. Second, then is the part of commercials. Commercials are generally, when it comes to scope of work, it's how the payment will be made, whether it will be in tranches, like milestone based, whether it will be made in lump sum at the end of the month, or it will be made at the end of the year when the project has been completed, or there are multiple milestones of a project. It will be depending on the percentage of work what has been created. And it will also tell you what is your invoicing methodology, whether you have to give a digitally signed invoice, whether you have to give a manually signed invoice, what will be the billing methodology. Timelines is how long the project is going to work. Is it for 6 months? Is it for 1 year? If after 1 year, do you want to extend it further for renewal or other things, those kind of. Project management is the resources who are going to work on that contract, and who will be actually managing the work from both the parties. So my experience tells me that when you are actually drafting a scope of work, it is mostly the operations or the business guys who gives you the document. Initial set of document for scope of work is prepared by your business guys or operations guys. Legal's role comes in after that. Legal will start reviewing it. When it comes to legal, what they have to keep in mind is the terminology and the definitions. When you are defining a deliverable, if the deliverable is like designing a website, then you have to define what kind of website is that, what will be your design specifications. So that definition has to be included, and it should be clear so that there is an understanding between the parties. What I'm expecting is being delivered from the other side. It should set goals and expectations for your project, that you will be performing the services within this timelines, in this manner, for this money, and by this you have to complete it. And all specification necessary for performing the work and services. For designing a website, you should be having the particular resources who are having an expertise. You should be having all kind of technology available, which will help in designing a website. So that kind of specification should already be mentioned. So it's always necessary that before, when you start negotiating a contract, you start negotiating on scope of work. Give your customer or your supplier of services or your supplier of goods a document which will give them the idea what actually you are expecting from them or what you are going to deliver to a particular customer. That is how the scope of work takes place. This is the first part of agreement, which is really, really important, and it's also considered to be the heart of any agreement. The second part of the second clause, which is actually very essential for any agreement, is reps and warranties, representation and warranties. A representation is what? It is a statement of fact. Fact, for example, my name is Romisa, it's a fact. So same way for organizations who are entering into an agreement, they have certain facts that they are incorporated, that they are validly existing under the laws of India, that like in my organization's case, that is Hinduja Global Solutions Limited, it is an IT and ITES enabled service provider. That is the truth and that is a fact. So same way, what is a warranty? Warranty is also a representation and a fact, but this warranty fact is about the future. So reps and warranties in any agreement actually reflects what the parties are entering into, what is their standing, and what are they going to provide presently, and what are they offering for the future. So in warranty, I can give you an example. For example, when we say that we give a warranty that I am going to be following or I will follow all the applicable laws for performance of these services or for delivering the goods. So when it comes to delivering of the goods, if it is a cross-border transaction, you have to actually follow the export laws. You have to follow the FEMA and other regulations, which comes into picture. So when you are saying that, yes, I'm going to follow all the applicable laws, I'm going to apply with them, that means you are giving a warranty for future. When you are giving reps and warranties under an agreement, it is always like that you are taking a liability for that. So in case, I'm going back to my example of laptops. So when you are giving a representation or a warranty that you are going to deliver 10 laptops, and out of that you are, yes, I am warranting that I will be delivering you 10 laptops in 10 days, but you are giving them at 8 laptops. So that means it's a breach of warranty, okay? So you're doing a breach of your liability. So you are taking a claim. So it's always essential that whatever you are actually presenting in the laptop is whatever you are presenting in a contract is something that is true and you are going to adhere to it, whether it is a customer or a buyer or a service provider. So it should always be negotiated and considered. So what should you do when you are drafting a representation and warranties clause? First and foremost is what I have seen so far in all the agreements is that people casually say that party represent and warrant and state the statement that I represent and warrant this. But that shouldn't be. You can only represent, you shouldn't be warranting, because when you are warranting, it creates an future liability for you. If future liability, if you are not doing, it will amount to a breach and will lead to a claim and you will be liable for it. So always restrict your representations and say that parties represent that. Second thing is try restricting representation and warranties to one clause. So there is a trend that representations and warranties are reflected in multiple clauses in an agreement. So it's always better to restrict into one clause and create one representation and warranties clause under the agreement, so that when you're going back to that representation and warranties, you know what you are quoting and what you will be liable for. That third thing is that ensure that your representations and warranties are aligned to your scope of work. Whatever promises whatever you are planning to deliver under that agreement should be, your representation should be aligned to that. If, for example, in a, say in a website design, you are representing that your design features will have these elements and it will be as per the governing law or applicable law of India. So when you are representing, you should be, when you are giving a representation and warranties, your representation and warranties should be aligned only to the Indian law. You can't say that I am confirming that I will ensure that, or I am also going to conform to the laws applicable in US and UK. So that is broadening your jurisdiction. So you shouldn't be doing that. Then you will get a claim from US and UK jurisdiction also. Second is the most important part is that limit your survival obligation for your representation warranties clause. That means that you should be liable if there is any claim for representation and warranties only during the contract period. If you don't set the survival period, then what will happen is that you can get a claim even after the contract has expired or terminated. And important point for warranties is that always include a warranty disclaimer. Warranty disclaimer is that you are going to adhere only what is written in the scope of work, or what is written in the contract, which is in black and white, which has been agreed and signed between the parties. You are not going to conform to anything which was there in my mind, but it was not in the writing. For example, if I am expecting moon, but I have mentioned only a tube light in my agreement, so I cannot blame my customer or my service provider tomorrow that you have only delivered me the tube light or a bulb, you didn't deliver me the moon, because that was all in my mind, that was not in my contract. So always put a warranty disclaimer saying that whatever is written in the agreement is the only true fact, and I'm going to adhere to that. I'm going to adhere to my contract. I'm going to adhere to my scope of work. If these things are not written in my scope of work or in my contract, then I don't have any liability for that. Best would be to have an amendment or an addendum at a later stage if there is something which is additionally expected from by the parties. Now, moving to one of the critical clauses, which actually takes maximum negotiation between the parties and is something which is always lingering till the end of execution stage. And it is something where mostly you don't get 100% of what your expectations are. That is indemnity and limitation of liability clause. Even before starting this meeting or this webinar, I was actually discussing with my manager for one of the contracts in Malaysia. So initially we didn't had a limitation of liability clause in our contract. Now the customer has introduced it at the renewal stage, that is almost after 6 years, which is a good thing because your contract should be always, your liability should always be capped. But we were deliberating, why has he now introduced? Why not at the initial stage? What are his intentions of introducing this limitation of liability clause? So these clauses are something which requires more brainstorming, which requires more thinking and should be restricted to contracts only. And these are the ones which actually leads to maximum kind of claims or disputes between the parties. So what is indemnity? Indemnity in a normal sense means a duty to make good of any loss. So when there is a breach of contract and the other party under the contract agrees that if there is any breach of any particular term and that breach is directly attributable to that party, then that party is going to pay the damages. But that covered under the agreement? That has to be reflected in the indemnity clause. Alternatively, we can also say that the right of an injured party to seek reimbursement for its loss, damage, or liability from a person who has such duty to pay. So it becomes important to have indemnity clauses in the agreement so that you can restrict your claims to those indemnity clauses. And second is the limitation of liability clause. What is liability or damages? Liability is the amount of damages lost that can be brought against you. So when we understand liability, there are two types of liability. The first one is direct, that is, which is directly attributable to the breach of any agreement term. Second is indirect consequential damages, for example, loss of profit, loss of reputation, loss of business revenue earning capabilities because of any breach which has resulted in it. So what should we agree? While drafting and negotiating, what should we agree, what should we consider, and what should we actually include in the agreement when we are defining that? First is that keep indemnities specific and aligned to project scope. So I was giving you an example of applicable law. So if your project is in India and you don't have any work-related aspects in UK or USA, so make the applicable law related indemnity for breach of applicable law in India. So don't make it breach of applicable law in India, UK, USA, because that is not aligned to your scope of work. Second part is be cautious of words, keep indemnified. This is a common language which is used in indemnity clauses, that the supplier agrees to indemnify, keep indemnified fully and on demand the customer. So be careful of using the word keep indemnified. That means you are continuously indemnifying them, even when the contract has expired or has been terminated. Fully means whatever that they are claiming. If the demand is for $100, then when they are raising a claim, you have to make the payment for $100. So that word shouldn't be mentioned there. And on demand, that means as soon as they are raising a claim, you have to make the payment. So what you have to do is you have to be very particular. You should always mention that supplier will indemnify or customer will indemnify the supplier. That's it, limited to that. Because what happens is when it comes to the indemnities, the process is that as soon as the breach is identified, the person who has been grieved or aggrieved has to raise a claim. Okay, once that aggrieved party raises a claim, it goes to defaulting party, and defaulting party has to review that claim and see what is attributable to them, whether it was caused by them or not. If aggrieved party is raising a demand for $100, and when the defaulting party is reviewing that demand and they see that it is only for $50, then they will pay only $50. They have to prove that it was for $50 only. So when they say that fully, so you can always counter that. No, the claim was $50. So I'm going to pay you $50. And it was only after they have done their due diligence and saw that, no, it is not on demand. It is after I have done my entire research and I have sought evidence, I have produced my evidence to you, and it is what is happening. So be very careful when the words like keep indemnified, fully, or on demand are used. Second is when you are setting your Direct damage is cap. So always do the risk reward analysis. That is how much services you are providing and what is the commercials you are receiving. So if you are setting a cap for, see, if your contract value is 100 million, but you are setting a cap for 200 million. So it doesn't meet that risk reward analysis. So your reward should be your risk intake. It can't be more than that. So do that research and see what is your reward and match the cap according to that. Always cap your direct liabilities and be particular about which liabilities to be capped, uncapped. So this is a particular aspect which is very critical when it comes to UK or USA or any other jurisdiction, especially when it comes to data protection laws. UK, you all must be knowing about the General Data Protection Regulation, that is GDPR, which came into place 2-3 years back. So it is very strict when it comes to personal data. And similarly in the US, the healthcare related personal health information is very, very critical. And if there is any kind of breach when it comes to healthcare information, so the liabilities are pretty huge. Okay, so you have to be very careful when you are actually taking liabilities for that. So you can't cap them. So you have to keep them as per the applicable law. So introduce the language that even if you are keeping them uncapped, but you are actually keeping them as per the applicable law. Don't keep it uncapped, keep it as per the applicable law. Exclude indirect, consequential, punitive, or exemplary damages. Reason being that whatever damage was caused because of your deeds, you will be liable for them. And if anybody is suffering a reputational damage because of it, so you can't quantify that, and that is not related to you. So always include an exclusion clause and exclude indirect, consequential, and punitive damages in that. Third important thing, which I was also talking when I was talking about the reps and warranties, is limit the survival obligation of this clause as well to the term. Always, because you don't want to get the claims once the contract has expired. You even forgot about that contract, but you are still receiving a claim. So keep the survival obligation only to the contract term. Moving forward, this is something which is very critical, and during pandemic, this is one of the clauses which was invoked by many parties actually. So that is termination. So when termination is that parties want to exit the relationship, so how to go about it? There are actually 4 methods which I have reflected in this deck. One is by effects of time, that the natural tenure or the natural period, validity period of an agreement comes to an end, so automatically it will get terminated. That is by effects of time. Second is convenience. That is if my business requirements are not, are asking me to actually terminate, not go about the agreement, and it's not being fruitful to me. So I just want to get out of it. So I will terminate the agreement for convenience. Then is the cause. If there is any breach of an agreement by either party, then the other party will be having a right to terminate. And then the last one is actually a regulatory aspect, which is relating to insolvency, bankruptcy, merger and acquisitions. So you always have a right in the agreements. You can always incorporate that clause wherein you will mention that I want to terminate the agreement because of these regulatory reasons. So what should you do? For effects of time, notice period is not necessary because the contract is coming to an end, say after 1 year, so it will automatically come to an end. But for convenience as cause, it is important to have a notice period so that when I want to terminate an agreement, I have to tell the other party that within 30 days, I'm going to terminate the agreement for this reason. So I am giving the other party a 30 days opportunity to look for an alternate, whatever services or supplies I was providing to them. For cause, when you are giving a notice period for cause, in that case, what happens is that you are giving an opportunity to the breaching party to actually rectify that breach. So if they are not rectifying within that 30 period time, so and then it means it is a rectifiable disease breach and you can't do anything about that. And then you have an option to terminate immediately. Insolvency or bankruptcy or any regulatory matters, mostly in insolvency and bankruptcy, it's an immediate termination. And if, for example, in banking contracts, if you have a contract with bank, if the bank has lost any license or something, then the regulator, say RBI, immediately asks them to terminate all their contracts or withdraw from all their transactions. So you don't get a notice period there. Same is with the SEBI regulated organizations or an IRDA, that is insurance related organization. These are all regulators. So when you get a notice from them, then the option of having a notice period is minimum. So you have to, it's generally the immediate termination. So it is always the notice period is to be served by a party intending to terminate the agreement. When I said that I want to terminate for convenience, it's me who will be serving the notice period. In this absence of termination clause, you will not be having any right to exit from that engagement. And second thing is that you will have to actually knock the door of court of law, because the disputes will definitely arise if you don't have an exit clause and you are actually exiting the contract, and that will lead to breach. So be particular when you are drafting your contract and when you are drafting the termination laws, be specific for what purposes the termination will be. The notice period can always be negotiated between the parties. It varies from 30 days to 120 days, depending on what is convenient and what is best in the best interest of the parties. The other important clauses which are really, really important. I didn't want to introduce the force majeure here. I mean, during pandemic period, actually, this became very important. And this is again the second clause after termination, which was invoked by almost all the companies. What does force majeure mean? Force majeure is an event which is unforeseeable. For example, a typhoon, cyclone, fire, earthquake, or in our case, it is pandemic like COVID-19. So what happened when the lockdown happened in India? So mostly the businesses were shut, people were not going, work was not happening. So many offices were closed because they were not getting revenue, they were not able to pay their employees. So when their customer agreements or the leases came into picture, they invoked this force majeure event. What does the force majeure clause helps you with? It actually gives you a temporary relief from performing your services or for paying your responsibilities under the agreement. So sometimes it is defined for 30 days, sometimes it is defined for 60 days. What has become important now is that earlier, I mean, I was also of the view that this clause is there. Yes, it should be there, but I will not give much importance to this clause. I will just negotiate it probably once, 2 rounds, and then leave it. Okay, if they are defining it, fine. Now, I have become very particular about this clause. What I consider is that pandemic and epidemic related terminologies are also included in there, especially which are notified by the WHO or the governmental authorities. And second is the option to terminate. Say if force majeure event has happened and the work has been stalled for say 6 months, not 6 months, 60 days. After that, I am not able to go back to the work. I really want to have an option to terminate. So what I have started doing is that I have started introducing a clause for an option to terminate if after a particular period, parties are unable to meet their requirements under the agreement. So that clause has been introduced. Second one is governing law and jurisdiction. So this clause also becomes important when it comes to the dispute resolution, especially, and the applicability of laws. So, and especially when it comes to the contracts which have a cross-border transaction. Say, if you have a contract with Singapore, so I mean, and an entity is in Singapore and the other entity is in India. So what do you want? So you should define which laws will govern, and always go for a laws which are easy to understand and are reliable and effective. For example, Singapore as a jurisdiction is something which is very business friendly. So if there is a contract between Singapore and Malaysia, So I will always go for Singapore because there is something which is very understanding, and the business nature of contracts in Singapore is easy to understand. Same way, it is a jurisdiction of where the disputes will be held. So I will choose either it should be either party's jurisdiction or a neutral jurisdiction. So that should be considered. The important part, the next important clause is the confidentiality. Confidentiality also includes sometimes privacy, data protection, and your security related obligations. So this clause is important, and when it comes to the domestic one, it's only Information Technology Act which comes into picture, because the Privacy Act is still to be in it's in the verge of getting into a law, but currently we don't have any specific law on data protection, privacy, or apart from Information Technology Act. So in that case, India-wise, it is little easy. But if you have a cross-border transaction where the entities are from different countries, so what you should ensure is that confidentiality also includes the data protection related clauses where the personal information is protected by both the parties. Second is that you have a privacy related clause in that where your personal information is protected, your health related information is protected, because as I have mentioned earlier, when it comes to US, the HIPAA or HITECH, these are two laws which are applicable to healthcare industry. So they are very strict, and the liabilities under these clauses are very high. Same is with GDPR, which is the General Data Protection Clause of EU. So this clause also has a very strict connotation when it comes to protection of personal information. So in these cases, you have to be very particular when you are drafting your confidentiality clauses. Exclusions to confidentiality obligations like information in public domain. So when you are defining your non-disclosure agreement or your confidentiality clause, you have to include exclusions, and don't take any liabilities for the information which is already available in the public domain, or which is where a party came to know about that information from a third source, not directly from the contracting party, or where any kind of information is developed independently by a party. So these exclusions have to be included. Here also, you have to be very particular about your survival period. So always ensure, first reason for survival period is that the compliance becomes easy if you are restricting it to only the contractor. Reason being that you don't have to put extra efforts after the termination or expiry of the agreement to ensure that the contract has expired, but still you have to ensure compliance, you have to protect, you have to create those measures, regulatory affairs, applicability of law and everything. So you don't have to worry about that if you are restricting the survival period to agreement term. Maximum what we do is that we give 1 year after the agreement term. Reason being that, yes, there are certain information which we will keep for audit purposes or for any regulatory requirement purposes, and sometimes even law like Companies Act requires you to keep information for 7 years. So, I mean, you have to make your survival obligation in that manner only, keeping into view the transaction involved. If it's a financial transaction and it involves the Companies Act, so you have to be mindful on the survival period. The last one is intellectual property and ownership. IPR clause is to identify the ownership and license of any kind of intangible property which you are developing. It may be your trademarks, which are very common when it comes to large organizations. It may be your copyrightable material. And if you are in a design or product development, like a product-based company who develops like Dell or Lenovo, so you have to be very careful about your patent rights or design rights. So when you are drafting a contract like joint development agreement or a licensing agreement, so always define this intellectual property and ownership clause in a more detailed manner and be particular about background IPs, that is the IPs which were existing before you entered into a contract. Foreground IPs, that is the IPs which were developed once you receive the specification from the parties. Based on the information, the IPs were developed, and the IPs which were joint developed, which were used after the parties exchanged their ideas, exchanged their information, and the IPs were developed. So this is what becomes important. And when it comes to IP, you have to be very careful what kind of licensing you are doing. Is it a perpetual license, or it is a time-bound, exclusive? Are you giving a worldwide license, or you giving a restricted license, say for USA only or for India only? You have to be very, very careful about these clauses. So that is it. Yeah, from my side. So these are the clauses which I think are very necessary and important, and should be considered specifically. I'm not saying other clauses are not important, but these clauses are very tricky when it comes to negotiation and takes most of your time during negotiating with the other party. So you have to be very careful while drafting these particular clauses, and should use all your negotiation skills to protect your interest, of the company or whatever entity you are representing, whether it is by way of a law firm or by way of a corporate structure. That is it. Let me know if you have any questions.
Thank you so much, ma'am. Thank you so much, ma'am, for the wonderful lecture and the presentation. And I hope our participants have benefited a lot from this. And ma'am, with your permission, can we just take a few questions?
Sure, yeah, please.
Thank you, ma'am. Ma'am, the first question is by Kamini Ahuja. She is asking, in a cross-border transaction, if one party is from India and the other is from Saudi Arabia, she's just taking an example. So it's from Saudi Arabia and governing law is Indian law and jurisdiction is an Indian court. How effective will it be, particularly for the execution of the decree?
Okay, if you're talking about the decree perspective, then I have to be very, you have to keep in mind the Saudi law is a Sharia law, which are very strict when it comes to their interpretations, and they are jurisdiction specific, and they are not, Indian law is also very cumbersome, and when it comes to especially the court structure and everything, it's a time consuming process. So if I am giving a opportunity to work with a company which is in Saudi Arabia, and the transaction is between India and Saudi Arabia, I would always suggest India as a law, because our laws are a little bit lenient, easy to understand, and the structure is better. When it comes to whether the decrees or something, that depends on what kind of, I mean, if it is a normal contract, so if you have chosen in an agreement that your governing law and your jurisdiction is both India, then it will be governed by India. And you do have an option that Indian courts will have an exclusive jurisdiction over any kind of award or anything under that agreement. But if you are keeping any kind of leeway that you can go ahead and go for any kind of award in any jurisdiction, then you have to be mindful of that. So if you are restricting it to Indian jurisdiction and Indian law, then it's easy. I am very careful. I'll give you an example. For example, when it comes to Middle East, especially Dubai, so we have an option not choosing Sharia law, because it's a stricter, and when it comes to interpretations also, it is a little bit of tricky. So what we do is that we do have an option to go for DIFC, that is Dubai Infrastructure Financial Something Committee. So they have their own structure of laws, they have their own arbitration system, and the laws are very business friendly, and they are commercially very economical. So that is what it is dependent on. So if you're choosing for two cross-border jurisdictions, that like Saudi Arabia or India, so always stick to one jurisdiction and choose that law which is convenient for you and which is business friendly. Out of these two jurisdictions, I would always go for India.
Thank you so much, ma'am. Ma'am, the next question is by Nisha. She is asking, what is the relevance of a company seal if contract is signed by one of the directors? Can that contract be enforced by law?
For enforceability of a contract, I have mentioned in my first slide that it has to be properly signed, it has to be properly stamped, and it should be in writing. If the contract is sealed by a company seal, round seal, if you're talking about that, then that will have a validity to prove that it was signed by an authorized person. It will depend whether the director you are referring to is an authorized person for signing an agreement or not. So if the board of directors or a board has not authorized that particular director to sign a commercial transaction agreement, so if he's signing that agreement without authorization, it won't be valid. So you need an authorization from the board to sign on behalf of a company. And seal also plays an equivalent part because it becomes easy to establish that it was from that particular company. But you need authorization to sign an agreement. Your second thing, the agreement should be in writing. Third thing, it should be franked to be enforceable in a court of law.
Thank you. Thank you so much, ma'am. Ma'am, the next question is from S. Venkatesh. He is asking, in the civil law tradition, contracts are shorter than their common law counterparts and attempt to address fewer contingencies. So how to deal with the choice of laws?
I have actually, I don't think so when it comes to the length or whether the contracts are shorter or longer when it comes to civil law or common law. But I do know that when it comes to common law, the interpretation and other things becomes easy because India is a common law country. So Australia is actually a civil law country. So when you are going for any APAC Australia related agreements, they become very difficult to interpret, and the length doesn't matter. It actually the context or a text of the contract matters.
Okay, ma'am. Thank you. Thank you so much, ma'am. Ma'am, one question is from a participant. He is asking, what events typically qualify as force majeure events?
Yes. Events which are unforeseeable, which cannot be foreseen. For example, earthquake, tsunami. Tsunami wasn't something which was actually a force majeure event. Or pandemic like COVID-19, it is a force majeure event. But to qualify as a force majeure event, it should be written in the agreement that a particular event is a force majeure event. If the most of my contracts didn't mention pandemic or epidemic as a force majeure event because I didn't have a visibility that this event will take into place. So what I did was I have introduced by way of an amendment the epidemic or a pandemic notified by the WHO to be a force majeure event. So your contract, actually a contract clause, that is a force majeure clause, should mention a particular event, which is an unforeseen event like fire, like earthquake, like your COVID-19, your tsunamis, or governmental strikes, sanctions, like Iraq. Okay, Iraq has so many sanctions from US. So, I mean, if you have governmental sanctions like those, so if it is defined in your contractual clause, then it will lead to a force majeure event. You have to keep this in writing in agreement. If it is not mentioned, it's not going to serve a purpose for you.
Thank you, ma'am. Ma'am, the next question is in continuation of the previous one. It's like, what are the consequences of a force majeure event on contractual obligations?
Actually, a good question. When I was discussing force majeure event, I didn't take it in detail because it's something which became very popular during pandemic only. Otherwise, people don't give any attention to this clause because there are other major clauses which affects the business. Okay, so so when it comes to force majeure event, so you have to be the following things have to be very understanding. First is that If a force majeure event like COVID-19 happens, you have to give a notice to, first you should be having a clause in the agreement. Not having a clause is also somewhat can be taken care of, but particularly you should define a clause in your agreement regarding to force majeure event. If a force majeure event which is defined in your contractual clause is happening, then there's a requirement to serve a notice on the other party that you are getting affected by this event, a force majeure event, that is, for example, COVID-19, and tell them that you will be invoking this clause. And if your clause is allowing you to take a 60 days reprieve, you will take those 60 days relief, and neither party will be liable for any kind of damages because you are not performing for those 60 days. Okay, one part is that. Second part is that if after 60 days everything becomes normal, you are able to perform your services, you will continue performing your services. You have to just mention to the other party that I will be resuming my services from this date onwards. But due to any circumstances, if the business cannot be reprived and you want to terminate the agreement, then you have to ensure that you have a clause in the force majeure clause which says that after 60 days period, the parties are unable to resume the services, then they have an option to terminate. So you should terminate the agreement because that is best in your best interest, rather than occurring losses, or rather than facing a indemnity or a breach in that way. So ensure that your indemnity clause is properly defined. For invoking an indemnity, your force majeure clause is properly defined. For invoking a force majeure, you have to serve a notice on the other party. It can be through an email or through a letter, informing them that this event has occurred and I am unable to perform the services. So I am taking this particular time period. And during that time period, neither party will be liable to each other for any kind of non-performance.
Thank you so much, ma'am. Ma'am, the next question is, what are the reasons to consider not using a confidentiality agreement?
I don't foresee any reason actually. I actually advocate for NDA, non-disclosure agreement, or confidentiality agreement. It is the first step that should be taken while entering into any kind of discussion with anyone, if it is for commercial purpose or if it is for business transaction, especially for an corporate structure. And when, for example, when you are hiring a lawyer or an advocate or a litigating lawyer, you should also tell them that whatever information, they are even bound by the Advocates Act. So, but still you should ensure that you are signing a proper documentation with them and binding them with that confidentiality provision. See what happens for a corporate business entity. Any information which is shared with other party is a valuable information and is sensitive. Especially if you are a big corporation, so what your customers become your price sensitive information, your processes become your price sensitive information. So you should be careful when you are actually communicating it with anybody who is not from your organization or who doesn't have a relationship with you. Relationship, when I'm talking about, is a written transaction agreement, okay, which has all the clauses and everything. If they don't have that relationship with you, you should not start discussion unless you don't have an NDA or a confidentiality agreement in place.
Thank you.
There is no excuse for not having a confidentiality agreement.
Thank you so much, ma'am. Ma'am, the next question is, when negotiating a contract, what references do you use for research material?
Yes. I was actually, we were recently, we have currently where I'm working, Hinduja Global Solution Limited, we have subsidiaries in almost 7 countries. So we were actually negotiating a contract with UK, that is between UK entities, and it's a government contract. So I generally go back to the law. The applicable law in that jurisdiction. For example, when it comes to UK, I was talking about GDPR, which is something which is very, very important. So I go back to the applicable law in that jurisdiction. I read the law, what is applicable in that, and then frame my clauses or my contractual terms accordingly. And it also depends on the transaction. If your transaction is something relating to design, something relating to website creation, or if your transaction is something relating to dealing with personal information, so you should definitely go back to the law. Don't do researching on the internet is good for drafting a contract, because you will get an idea. But when you are researching, take clue which laws they are referring to, go back to that law and read that law. Read the Bear Act, what we are saying in India. Bear Act is your guide, is your actually Bible.
Thank you so much, ma'am. Ma'am, next question is, do you think law schools should teach contract drafting in curriculum? What are your views, and will it be useful for our young advocates in their initial years?
Yes, in Jamia, actually, I was taught drafting. We had a 6 months course for drafting actually, and lucky for me, during my exam, the elevated metro actually was happening. So I was reading the newspaper, and I saw that there was an article on elevated metro line. So I got a question on metros for drafting a metro tender, this one. So I use that knowledge. And I had actually a litigation lawyer who was litigating on the civil matters, who helped us in taking on the drafting classes. I think drafting is very important, and it's not necessary for if you are in a corporate structure. For law firm, their majority of work is relating to drafting only. And for litigations also, you have to do your pleadings, and everything are in writing. So you have to draft your pleadings. So contract drafting should be a part of syllabus. And as per my understanding, it is there. It should be there, especially in 5-year law courses, it is there.
Thank you so much, ma'am. Ma'am, with your permission, just one last question.
Yes, please.
Thank you, ma'am. Ma'am, what is the contract management and what are its benefits? A student is asking.
Actually, nice question. Contract management, okay. I'll give you an example from where I am working. So contract management is totally different than doing your normal contract work in an organization. So contract management is keeping it's actually a repository keeping. It will depend on whether you are a pre-execution repository keeping of a contract or post-contractual obligation tracker. So that becomes very important. First thing is that it creates a repository that should be based both on virtual mediums, and second is the physical copy repository. Second thing is that that it keeps a track of your post-contractual obligation trackers. So if you have any post-contractual obligations under the agreement, so contract management actually helps in that. So you have many tools in the market which helps in contract management. You have like iCertus, you have Lexplosion, you have Exigent, which are selling commercially usable contract management tools. So it becomes very important, especially for repository purposes and for post-contractual obligation trackers. Why? When I am referring to post-contractual obligation, that means when the contract is getting expired, if there is a requirement for insurance renewal, so it will track that also. When I'm referring to that, do you have any kind of certification requirement under the contract? So it will take care of that. That is contract management. Is there any obligation for insurance? That will take care of that. Do you have to give certain audit requirements? It will take care of that. So actually, when it comes to contracts, management is a separate field and is an equally important field to keep the repository and to manage the agreements. It actually a different question, but a very interesting one. Thanks for that.
Thank you so much, ma'am. Thank you so much, ma'am, for the wonderful presentation and answering the questions that have been put up by our curious students, I must say, and participants. Thank you so much once again on behalf of Keli Society, Keli College of Law, Navi Mumbai. I extend my sincere gratitude to you, ma'am, for accepting our invitation and coming to give this wonderful lecture. Thank you so much, ma'am.
Thank you so much. And I'm really, really grateful to all the participants for listening so patiently and raising all the questions. Everything was so interesting. I look forward to interacting with you more. So thank you so much.
Yeah, thank you, Romisa. I mean, it was an fantabulous lecture, let me tell you, and interesting questions, and you have answered them very nicely. Definitely, we will be looking forward to have at least sometimes a panel discussion on these related topics of contract drafting and other cases. Once again, I would like to thank you on behalf of KLE Societies, KLE College of Law, Navi Mumbai, for joining us and giving such a valuable information to our students and other participants. Thank you.
Thank you so much, everyone.
you.
Thanks a lot.
Thank
Have a
you,
nice
ma'am. Now
evening.
I request Tejashree to kindly propose the vote of thanks. Tejashree, over to you.
I'm thankful to have this opportunity to propose this vote of thanks on behalf of my honorable college, Kelly Societies, Kelly College of Law, Navi Mumbai, for this session. I extend my gratitude to Ms. Romisa Bhat ma'am for taking time from her busy schedule to honor this session with such an interesting and informative interaction. We have learned a lot today. Thank you so much, ma'am. I would also like to extend my gratitude to the respected members of KLE management for their blessings. Dr. Prabhakar Kore sir, Chairman of KLE Society, Mr. Mahantesh Kavadigimat sir, Governing Body Chairman of KLE College of Law, Member of Legislative Council and Chief Whip of Government of Karnataka. Dr. Mallikarjuniya, Principal of KLE Society's KLE College of Law College, Bengaluru, and the Director of KLE Law Academy, Bengaluru. A big vote of thanks to our respected principal sir, Professor Dinkar Gite sir, for giving us this chance to be present in such a wonderful session. My heartfelt gratitude to all my dear teachers for their constant support and guidance. Thank you to the whole team of webinar for making this session a success and uh, and last but not the least to you dear participant for being the most important part of our webinar. Thank you once again, one and all. Thank you so much.
Thanks a lot. Bye-bye.
Thank you. Thank you, ma'am. Thank you, Principal sir.
Thank you, ma'am. Thank you. Have a nice day, all of you. Yeah, you may end the session.